Good afternoon, Mr. Chairman, committee members. I'm Lin McCraw, and I am representing Texas Trial Lawyers Association. We are against the bill as filed. I'm not going to rehash a lot of the ground that Mr. Smith just covered because he covered it very well and very succinctly on point. There is a companion in the Senate that has shall to may. We've talked about that. We believe that that is the appropriate remedy if there is one at all. But I wanted to take just a brief moment to take us through the history a little bit of how this came into being. This was part of the 2011 losers pay bill that was heavily negotiated by all sides that ended up in an agreed bill, and that's what created Rule 91A, and it was created with mandatory fees both ways for a reason, because we did not want it filed in every single case. And the bill as filed, most defense attorneys would file it in every single case, even cases they knew facially were not frivolous cases, that they were good cases. They would file it in every single case because it becomes a why not motion. That's not appropriate. The losers pay bill, CH HB 274 in 2011, was designed, and in the Senate history it was there to make things more efficient, less costly, and more accessible to the litigants. This bill, as filed, does exactly the opposite in each of those areas, as Mr. Smith explained earlier. I won't belabor the point. I don't believe that we should run up the cost and have plaintiffs and defendants fighting in every single case on a motion to dismiss. And with that, I'll close and take any questions.
Mr. Chairman.
Any questions, Mr. Schofield?
I'll tell you, I'll look at what Mr. Rinaldi asked the last witness. You must have had different clients than I do. My clients don't like to pay for a lot of my time, and if I'm going to write up a motion and tell them it's going to cost X thousand dollars for me to do a motion up, if it's not likely to be a winner, they don't want to see the bill. I mean, y'all on your side of the bar may have a different view of what happens on our side of the bar than really does. Y'all ought to take a few defense clients from time to time. Or maybe you got guys that just are happier to pay your bill than I got.
Well, Mr. Schofield, very frequently what we would see in issues like this, I would expect that would be almost form driven, especially if there's no penalty for it. And I do, one of the things that I wonder about here is whether or not that Rule 13 could even be used if this bill was to pass as it was written, because it says, that notwithstanding, the rule may not require cost and attorney's fees awarded to the plaintiff, essentially. And for that reason, I'm not sure that Rule 13 would even apply, because this is a more specific statute as applied to a more general statute in Rule 13. So for those reasons, like I said, I do believe that there's middle ground here. I do believe that there's ground that would allow a judge to award fees if and when they thought the motions were not warranted at all, but not award fees if everybody had a good faith belief and we went to court and we fought it out, and at the end of the day one side or the other just didn't carry the day, but it clearly wasn't anything that was frivolous. So there's middle ground here.
On another sort of a further out aspect of it, if we were to do something that occasioned more of these motions and would bring the parties earlier into court to lay out basically their case, do you think that would have a salutary effect on early resolution and settlement and at least everybody knowing where they're going to be?
I don't think that,
except in complex cases, experts and that kind of thing.
I don't think that, because most cases most cases are going to require experts in these situations anyway. I don't think that we're going to see any earlier resolution. It's been my experience on my side of the bar that nobody wants to talk with you until literally you have them in a position that they cannot win at all. There's never a chance. At that point, that's when they get serious about settling the case. Until then, they don't. Until you've gone through discovery, until they've had their person deposed, their client deposed, and they see just how good or how poorly they did in the deposition and that sort of thing. And very often, with the advent of mediation required in almost every case, defense lawyers don't even want to talk about settling the case until you get to the point of mediation. So I don't think it's going to help quicker resolution of these cases, of the valid cases anyway.
Mr. Chairman,
So, Mr. Gutierrez.
other than churning the file, that's not your testimony, that's mine. So other than defense lawyers churning the file a bit, what is your understanding or your experience with judges when it comes to these types of motions? Is it your experience that judges want to see some further actual discovery done on these cases before they make these important decisions?
I think that they probably would. I haven't seen a lot of these filed because, again, this is instituted in 2011, and I don't file frivolous cases. You know, I mean, I'll try to take great care to make sure that my cases aren't, because I do my cases on a contingency fee, and if I don't have good cases, I don't get paid, and I'm wasting my time and my money and not supporting my staff, which I need to support with my cases. So I haven't had these cases, the 91A motions filed against me, because I have to take great care to make sure that we have good cases to begin with.
Very good. Thank you, Mr. McCraw.
Okay, Mr. Rinaldi has a question.
Yes, sir.
No, I just had a question. You brought up Representative Hughes's bill in the Senate. Are you on that bill, or have you taken a position on that version of the bill?
We've talked to Representative Hughes, and we told him that we thought that would be a good compromise for both yours and his together. We think that will work, and we've communicated that to him.
I'm just trying to clarify your position,
Sure.
if that version moves versus this version. Thank you.
All right.
By the way, I wouldn't refer to him as Representative Hughes.
I'm sorry. I forgot.
Mighty on that side of the building.
Well, I've known him a long time.
All right, any other questions? Okay, thank you, Mr. McCraw.
Thank you.